Okay, why don't we get started? Thank you all for being here today. Welcome to the Department of Justice Seminar on Public Records Law and Open Meetings Law. We're very grateful to our hosts for making this nice facility available to us today. And we're also lucky to have here today to make some introductory remarks Wisconsin's Attorney General J.B. Van Hollen, who I now introduce for you.
Thank you. I couldn't tell. Is this working? I hear yes and I hear no. Can you hear me without it? All right. I just wanted to stop by briefly to thank you all for being here. I think it's a tremendous, it speaks volumes, I should say, about our society that we have this many people in this many different walks of life, this concerned with the subject matters of transparency in government. And it's real interesting because we've held a number of these seminars across the state. We are going to continue to hold a number of these seminars across the state. And the last one that I spoke at and gave welcoming remarks, I happened to give welcoming remarks right in the middle of the seminar because it was all I could do to find the time to breeze in and breeze out because it was the day after the tragic shootings in Crandon. The seminar was in Rhinelander, so it was conveniently located for me to be able to shoot out there. But of course, I had to go to Crandon, then leave, and then go back to Crandon. And the interesting part about it is that is an experience in my life, and specifically in this position as Attorney General, where we were forced within the Department of Justice to make many of the same balancing decisions that the open meetings and public records laws call upon all of us to make in government on a daily basis. And that's why it's so important that we have the opportunity, to the degree that we can within the Department of Justice, to give you our ideas on the interpretation of the laws in those two very complex areas, to make sure that, to the degree possible, we all make the right decisions on the front end. That we make sure that we appropriately balance the need to have transparency in government with the need to apply the statutes and other laws that require us to the contrary, and the need to protect our citizens in cases where there are exceptions and full disclosure or open meetings are not the appropriate way to go forward and to do business. I will tell you going in, and I know this from experience as a district attorney and experience as Attorney General, that there are going to be far, far more areas within these two categories of the law for which we do not have definitive answers at this time and won't unless we look at them on a case-by-case basis. But what we hope to do here through two expert assistant attorneys general out of the Department of Justice who specialize in these areas is to provide you with some background and framework of the law in Wisconsin as it applies to open meetings and public records. We want to do this because we get, I believe last year we got approximately 600 calls within the Department of Justice asking specific questions or with specific complaints about open meetings and public records. We believe, based upon a lot of the context we have, that an awful lot of the violations were unintentional. Unintentional, but were done just because it's a convoluted area of the law and an area of the law where a lot of people in local government don't have a firm grasp of what to do under any given circumstances. We want to do the best we can to lay out the framework of the law for you and to make sure that you know that we within the Department of Justice want to be there as a resource for you throughout the course of the coming weeks, months, and years when you have specific fact circumstances that give rise to concerns by you. We want to make sure that government has as much transparency as possible. By the same token, we want to make sure that when transparency is not permitted under the law, or a lack thereof is permitted under the law, and the public interest demands or dictates that you make sure that the public interest is going to be something that is first and foremost. It's a true balance. You're going to hear, and you can see through the handouts, a number of things that talk about the balance. I believe we in the Department of Justice provide a very objective viewpoint when it comes to open meetings and public records. The reason I believe that is because, just like any other agency, we have to respond to such requests ourselves as recipients of public records requests. We also, along with district attorneys around the state, in certain circumstances, have to prosecute people for violations of these types of laws. And so we have the prosecutorial bent and viewpoint as well. But we also defend. Being the representative agency legally for state agencies, there are a number of cases where there has been an accusation of lack of compliance with the laws where we are on the defending end as well as their attorneys. The fourth area where we play a role is when it comes to appellate court work. The Department of Justice does more appellate work than anybody else in the state of Wisconsin in both our courts of appeals and the Supreme Court. In that area, we have the opportunity to take many of these fact circumstances that haven't been heard before, apply the law, and to try to get clarification in these areas of the law in unique circumstances through appellate decisions. We have an awful lot of experience in dealing with this area of the law, as I mentioned, from several different perspectives. We want to make sure that you have the benefit of all of that experience that you can possibly have. That's why we're here today. We'll do our best to give you an objective, adequate presentation and to answer your questions. But I can tell you from past experience, and I can tell you from my knowledge in this area and from dealing with my comrades in the Department of Justice, that many, if not most of these cases are fact-specific. If you have fact-specific questions, don't be surprised if you can't get clear, deliberative answers from the experts who are here today. That is because these areas of the law are so complex and apply so differently to so many different situations. That is why it's so important that you come here and try to get a base, as much as we can give you a base, of the legal outlines and parameters of open meetings and public records. Once again, I want to commend you for being here. Wisconsin, I believe, has historically been a state that has tried to advance openness in government as much as possible. All of you folks being here, I think, speaks volumes about the fact that the individuals around the state want to advance that concept as well. So I appreciate your attendance. I look forward to hopefully having a good conference. Thank you for being here. I look forward to seeing you all around in the future.
Okay. My name is Tom Bellavia. I'm one of the attorneys at the Department of Justice who works in the area of open meetings law, and that's what I'm going to be talking about for the first half of the program today. And then in the second half of the program, one of my colleagues, Maureen McGlynn Flanagan, is going to talk about the public records law. Before I start, there are two housekeeping things I have to address. One is for the attorneys in the audience, if you didn't sign in on the sign-up sheet when you were coming in and you want to be registered for purposes of getting CLE credit for your attendance here today, be sure before you leave today to sign up on that sheet at the tables out front. And the other thing is, if any of you are here during working hours and you need proof of your attendance here for your employers, they have slips at the front table as well that they will fill out for you and give you for that purpose. Now, proceeding to the open meetings law. The open meetings law is very easily summarized in its basics, but much more complex in its application. It can be summarized in one sentence. It requires that all meetings of governmental bodies in the state must be preceded by public notice, must be held in a place that is open and reasonably accessible to all members of the public, except in limited situations in which a closed session is specifically authorized. That, in a nutshell, is what the open meetings law says. But in practice, many difficulties and complexities arise. Now, in the approximately hour that is available to me here today, I can't possibly cover all the detailed issues and the more complicated problems. What I can do, hopefully, is give you a solid introduction to the basic principles and get you ready to ask the right kinds of questions to go where you need to go to answer your own questions as they arise. Now, the first point in that regard that I want to cover before I get into the substance of the open meetings law is where you go for additional information, because undoubtedly after you leave here today and you actually encounter an open meetings law question, you're going to encounter one that wasn't answered during the presentation today. So what do you do next? The first thing I would advise you to do is to look at the Open Meetings Law Compliance Guide, which has been made available. There were copies as you came in on the table. This is a booklet that's produced at the Department of Justice by the attorneys in this area. It includes the first 22 pages, I believe, are a description of the basic issues in the Open Meetings Law and our analysis of the law. And then there's an appendix that includes the text of the law itself and some other materials. One thing about this book that you should be aware of is that it is also available online at the Department of Justice website, and that is a particularly valuable resource because this book is loaded with citations to Attorney General opinions and to correspondence from the Department of Justice responding to various kinds of questions about the Open Meetings Law. Many of those documents have links in the online version where you can just click on the link online and have immediate access to letters that have been sent out over the years or Attorney General opinions. We don't have links to the published cases because those are readily available in their published form anyway. But that is a resource you should be aware of and we encourage you to take advantage of. Second, there was a white sheet on the table today that includes a little bibliography of references related to the Open Meetings Law. I think it's self-explanatory. It's a list of books and other resources that are pertinent to this area. And I would advise you to utilize those resources as well. If you don't find the answer to your question from those sources, and if you are a member of a governmental body or a municipal clerk or someone who's working with or for a governmental body, we encourage you to consult with your attorney for your own governmental body about your question. Don't guess. Ask your attorney. In addition, the Attorney General's office is statutorily authorized to provide advice to anyone as to the applicability of the Open Meetings Law under any set of facts. So both members of the public and government officials can contact the Attorney General's office either by telephone or in writing with questions about the application of the Open Meetings Law. Depending on the complexity of your question, it may or may not be one where we have to ask you to send us additional information or to submit it in writing. It just depends on the circumstances of the particular case. Now, at the beginning of talking about the Open Meetings Law, we always like to start by talking about the purpose and the public policy of the law. And this is an instance in which the state legislature has provided a specific statement of policy in the statutes at section 19.81 sub 1. And I'll just read it because it sets a nice tone for the general meaning of the Open Meetings Law. It says, "In recognition of the fact that a representative government of the American type is dependent upon an informed electorate, it is declared to be the policy of this state that the public is entitled to the fullest and most complete information regarding the affairs of government as is compatible with the conduct of government business." The fullest and most complete information compatible with the conduct of government business. That is the basic policy. In order to promote effective representative government, that's what we're trying to provide. And the legislature has also provided an interpretive guideline for construing the Open Meetings Law, which says that the Open Meetings Law in most circumstances is to be broadly interpreted so as to promote that policy of open government. In other words, if you have a difficult question, if you're confronted with a situation, you're looking at a provision in the law and you're looking at your facts, and it just seems really fuzzy and it could go either way. You're not sure. You could justify maybe having a closed session or maybe not, depending on how you construe the meaning of a term. The legislature has instructed you and the courts and everyone to favor the interpretation that promotes open government rather than to favor the interpretation that promotes closedness. So that's the guideline. It's the tiebreaker principle, if you will. When in doubt, err on the side of openness rather than closedness when applying this law. Now, the first question that comes up under the Open Meetings Law is, when does it apply? And that is a question that is largely governed by the definitions of two terms that are defined in section 19.82 of the statute. And those two terms are governmental body, and the second term is meeting. Now, the term governmental body is one of the trickiest terms to apply in the open meetings law. It's discussed at some length in the compliance guide at pages 2 through 5, and I would encourage you to look that over at your own convenience. The statute defines governmental body in general as state or local agencies, boards, commissions, committees, councils, departments, or public bodies, corporate and politic, created by constitution, statute, ordinance, rule, or order. Now, what does that mean? It's a long list of all different sorts of collective governmental entities. But the most important thing to notice about the definition is that governmental body is not defined primarily in terms of the kind of governmental power that the body exercises. It's not defined in terms of how the body is funded, whether the body gets its funds from public treasury or not. It's defined primarily in terms of the way in which the body is created by constitution, statute, ordinance, rule, or order. Now, constitution, statute, ordinance, possibly rule, are fairly straightforward because there are written sources you can go to look at those. If the Constitution creates a body, it's covered by the open meetings law. If a text of a statute creates a body, it's governed by the open meetings law. Same thing for an ordinance or an administrative rule. But order is a trickier term because you can't go and pull the order book off the shelf at the law library quite so easily. And in fact, the Attorney General's office has construed the word order in this definition fairly broadly over the years as including any kind of directive that creates a body and assigns it duties, including it can be a formal directive or an informal directive. It can be a directive issued by a governmental body itself, or perhaps by other government officials, such as heads of state agencies, or in some circumstances, possibly even lower-ranking government agency officials. So for an example, say you have a school board, and they're talking about budget issues, and they decide that they need input from certain members of the public regarding these budgetary issues, and they want to form a citizens advisory committee. So without passing an ordinance or even taking a formal action, they issue an informal directive to the superintendent of schools, see to it that go out and locate some appropriate people from the business community and parents and from our municipality and form them into a citizens advisory committee, report back to us in a month or two with your recommendations regarding these budget questions. That would probably be considered an order that created that Citizens Advisory Committee and assigned it its duties. The Citizens Advisory Committee would be considered a governmental body subject to the open meetings law. It's very important to be aware of that issue because often, especially with Citizen Advisory Committees, citizens aren't accustomed to acting as public officials and don't realize that all of a sudden, by agreeing to serve on an advisory committee, that they're subject to the open meetings law, that they're participating in a governmental body. So that's how that principle of creating a body by order comes into play. Now, governmental body, the definition also includes subunits of a governmental body. So if you have a municipal board, its committees and subcommittees are also considered bodies that are subject to the open meetings law. As I already said, it includes purely advisory bodies. The nature of the power that the body exercises is secondary. So it doesn't matter whether they have final decision-making authority. We often get questions, well, this body it doesn't really have any power. It doesn't really do anything governmental because it just gathers information and provides advice. Does not take it out of the scope of the open meetings law. Purely advisory bodies are covered by the open meetings law if they otherwise fit the definition of a governmental body. The concept is not unlimited, though. Not everything in the world is a governmental body. And there's a category that we sometimes use to talk about gatherings of people that aren't governmental bodies. And It's inherently a fuzzy category. It's called an ad hoc gathering. And sometimes we talk about whether something is a governmental body or an ad hoc gathering of people who have come together to talk about, to talk about some subject. There's not an absolute rule that can be applied to determine whether you have an ad hoc gathering or not, but there are some factors to consider. If the gathering isn't designated anywhere as an established specific collective entity, as a body, then that's one factor that might lean toward making it an ad hoc gathering. If it doesn't have fixed membership, if it's a gathering of people and who attends any given meeting varies from time to time, there's no list anywhere of who's really a member and who isn't, then it's probably an ad hoc gathering and not a governmental body. If there's no process for collective decision making, the body just kind of gets together and everybody just talks about whatever they talk about, but there isn't really a formal process for how they make decisions or what it is that they do. It's more likely to be an ad hoc gathering. And one example that comes up from time to time is departmental meetings within government executive branch departments. When department staff meet with the head of a governmental department and some members of the staff attend a meeting or not, that's usually considered that's not a meeting of a governmental body. It's more of an ad hoc gathering. The bottom line with regard to governmental body is that this is an extremely fact-specific. I think it is the most fact-specific area of the open meetings law. And when you look at those pages in the compliance guide, you will see that a big portion of those pages is just a long list of things that have been determined over the years to be governmental bodies or not. And you just have to kind of look at see, what is and what isn't on a case-by-case basis, and it's sort of an art then to see to look at the next case that's a little bit different. So it's really an area where if it's unclear to you, you are encouraged to seek assistance from your attorney or from the Attorney General's office at the earliest opportunity for determining whether if you have a body and you're not sure whether it's covered or not. Now, the second term that governs the applicability of the open meeting law is meeting. Assuming that we have a governmental body, when do we have a meeting of that body? Is it only when they have something that they formally designated as a meeting, or could there be some other kind of gathering of the members of the body that would be considered a meeting? The statute defines a meeting as the convening of the members of a governmental body for the purpose of exercising the responsibilities, authority, power, or duties delegated to or vested in the body. Now, in applying that definition, the Wisconsin Supreme Court has established a two-part test, which is often referred to as the Showers test because it came from a case called the Showers case. That test encompasses two requirements, a purpose requirement and a numbers requirement. Under that test, a meeting occurs whenever, one, the members convene for the purpose of conducting government business, and two, the number of members present at the gathering is sufficient to determine the body's course of action. So I'm going to talk about both of those requirements briefly. First, the purpose requirement. The purpose of conducting governmental business is not limited to formal or final decision making. This goes along with what I said earlier about advisory bodies. Conducting governmental business can include preliminary decisions, just discussing, or simply information gathering. The members of a governmental body do not have to interact with one another in order for a meeting of that body to take place within the meaning of the open meetings law. If the members are present and they just look at a site of a public project or watch a presentation on some subject or listen to members of the public or anybody else talk to them about something related to the body's business, that's a meeting of the governmental body, or they are conducting government business, even if they say nothing and just passively receive information. It also should be noted that the statute provides a presumption under which if 1/2 or more of the members of a body are present in one place at one gathering, that gathering is rebuttably presumed to be for the purpose of conducting government business. So if half or more of the members are present, then they automatically are going to have the burden. If someone challenges whether they were conducting government business at that gathering or not, they're going to have the burden of proving that they weren't doing government business. Now the second requirement is the numbers requirement, and that means a sufficient number to determine a course of action by the body. Now, the key here is to remember that the body's course of action can be determined in two ways, either positively or negatively. The simplest way is positively. The body decides to do something, it passes a resolution or it passes an ordinance to take some action. But the body can also decline to refuse to pass some action. If the number of people sufficient to block an action by a body may be different than the number of people necessary to pass an action. If the body operates under majority rule, then it takes half plus one to affirmatively pass an action. If you have exactly half of the members of the body opposed to the proposed action, that's enough to prevent the formation of a majority in favor of that action. So it's not necessary to have half plus one, which would usually be, most typically, that would be the definition of a quorum for the body to hold a formal meeting, right? A majority of members of the body are present. But if you have exactly half of the members, that is a sufficient number to control a course of action by the body if it's an action that can be governed by majority rule. That's what we call a negative quorum. A negative quorum is enough to block an action by the body. So under majority rule, exactly one half of the members is a negative quorum, and it becomes especially important when you have circumstances where bodies are called upon to make specific decisions by supermajority, which happens from time to time. If you have a decision that requires a 2/3 majority to pass, then any number greater than 1/3 of the members would be sufficient to prevent the formation of the 2/3 majority needed to pass that action. In that context, then more than 1/3 of the members would be a negative quorum, and any gathering of more than 1/3 of the members would pass the numbers test and potentially be a meeting under the open meetings law. Now, I also want to point out that definition included the phrase a convening of the members of the body. And convening is a very interesting term, because in its simplest meaning, it's pretty clear what it means. We are all convened here today because we're gathered in one room. We can all see one another. It's face to face, and we can all talk to each other and have a conversation. And I don't think anybody would doubt that we're all convened here today. But that's not the only way to convene within the meaning of the open meetings law. In fact, the concept of convening can include not only face-to-face gatherings, but also other situations in which the members of a body are able to effectively communicate with one another and to exercise the powers vested in that body. So the critical question, even if they're not physically present together in the same place, if they're able to interact in a conversation-like way and exercise their duties as members of that body, then they may be considered to be convened. The key is the extent to which the communications in question resemble a face-to-face exchange. So, simple example, written correspondence. Common situation is one where a written document is sent out to all the members of a governmental body in advance of a meeting, or some document is circulated to or among the members of a governmental body in advance of a meeting. Does that constitute, does the receipt of that document, written document, by the members outside the context of a formal meeting itself constitute a meeting? In general, the Department of Justice has taken the position that it does not, because hard copy written correspondence has characteristics that make it unlike face-to-face communication. It is usually one-way communication. If there are any responses, the responses are generally greatly spread out over time. Numbers of members don't communicate with one another simultaneously in that way. They don't all receive the same message and send out the same response at the same time. And so it's our position that in general we think courts haven't decided the question, but we believe courts would be unlikely to decide that the circulation of written documents would be considered a meeting within the meaning of the open meetings law. One caveat to that point, however. In a couple minutes I'm going to talk about an idea called a walking quorum, which is when small groups of members talk to one another separately and they kind of play a game of telephone with one another, and in the end they've all effectively talked to one another without really ever having gathered in one place and had a meeting. It is possible for written correspondence to be used in a way that that accomplishes a walking quorum violation of the open meetings law. So you still have to be careful for that, but setting aside the walking quorum problem, written documents, written correspondence would not be considered a meeting. Now, or a convening of members. Now, at the other end of the spectrum, you have things like telephone conference calls and video conferences. These are things that, for practical purposes, are indistinguishable from a face-to-face gathering. If the members all gather together by video conference, they can see one another, they can hear one another, they can interact with one another, and it's virtually the same thing, absent the visual part, for telephone conferences. So we've long taken the position that both telephone conferences and video conferences would be considered a convening of members for purposes of the open meetings law. So if you have a telephone conference for the purpose of conducting government business and it involves a sufficient number of members, it is a meeting subject to the requirements of the open meetings law. What about other forms of electronic communication, especially email, but also things like instant messaging or electronic bulletin boards? These are forms of communication that are kind of in between written correspondence and telephone correspondence because they're partly electronic and instantaneous and partly written. And our courts have not decided this question to date, but the technology creates the risk that it could be used to carry on private discussions among members of a governmental body outside the context of a duly noticed public meeting. So our office currently advises using caution in the way in which email and these other forms of communication are used by government bodies as a means of communication among the members. And we think that what the courts are likely to do when they're eventually called upon to address this is to look at the extent to which an exchange of messages looks more like a conversation or more like a written letter and a reply. And the factors that are likely to be considered would be things like how many members of the governmental body were involved in the communications. How many messages were sent back and forth regarding the subject in question? What was the time frame within which the messages were exchanged? Was there a lot of very rapid exchange of information, or was it spread out over days or weeks? And to what extent does the substance of these interactions, is the substance of the discussion conversation-like in nature? Are they really doing government? Are they really talking about government business in these messages? Depending on how those questions are answered, the use of these kinds of media of communication might or might not implicate the open meetings law. So to avoid the risk of inadvertently violating the open meetings law, the Department of Justice is currently advising governmental bodies as much as possible to use email only to transmit information one way to the members of the body, and to discourage the use of it for replies, to particularly discourage discussions of government issues through the use of email, and in particular to avoid the use, if you do have to send a reply to a message for some reason, to avoid the use of that reply to all button in your email program, which is especially dangerous because it automatically passes the numbers test. Now, walking quorums I mentioned earlier. The Supreme Court, in a decision back in 1976, said that a meeting can also include a series of gatherings among groups of members of a body, each of which is itself smaller than a quorum in size, who agree, either explicitly or tacitly, to act uniformly in sufficient number to determine the body's course of action. So A talks to B, B talks to C, or member C talks to members A, B, D, and E, one-on-one, separate conversations, and they all talk about the same thing, and B agrees separately with each of them that they're all going to vote the same way on some motion at an upcoming meeting. That might be a walking quorum because they've all agreed. They've agreed through this series of conversations, assuming that when you put them all together, it's enough to constitute a quorum or a negative quorum. They may have all agreed to act uniformly at the upcoming meeting, even though there was never any point in time where they were all convened in one place or convened through any of these other methods I described before. But it's important to note that agreement is a necessary element of the idea of a walking quorum. If there isn't either an express or an implicit agreement among the participants in the alleged walking quorum, then there may be no violation. So if a series of exchanges have occurred among separate small groups of members, but there has not effectively been any agreement to act uniformly in any way about any item of business pertinent to that governmental body, then there probably would not be a walking quorum found. So that's one area where the violation category, I think, would probably be fairly narrowly construed by the courts. Now, the last idea related to the definition of meetings that I want to talk about is social or chance gatherings. The definition of a meeting excludes any social or chance gathering of the members of a body unless the gathering is intended to avoid compliance with the Open Meetings Law. Now you'll remember that if half or more of the members are present at a gathering, then they have the burden to prove that that gathering was not for the purpose of conducting government business. In other words, they essentially had the burden of proving that this was just a social or chance gathering and they weren't really doing government business. If a quorum of a body gathers by chance or at a social occasion, and they do discuss business during that occasion, then that discussion probably would be viewed as an attempt to avoid compliance with the Open Meetings Law and would be considered a violation. So it's important, an important rule of thumb is if you're a member of a governmental body and you happen to end up at a social occasion or by chance you encounter a sufficient number of your colleagues on that body to pass the numbers test, don't talk about government business because no notice was given. The public was not given any opportunity to attend that discussion. So don't do it. Now, the other issue that comes up with the definition of meetings, the last thing I want to talk about, is multiple or overlapping meetings. And this is what happens when you have a quorum of the members of one governmental body, called government body A, and they attend a meeting of a second governmental body, body B, because they want to gather information about some subject that's relevant to the work of both body A and body B. In that situation, the gathering of the members of body A is considered a meeting of body A as well as of body B unless that gathering was social or chance. And this is the rule that's called the bad key rule. It's derived from a Supreme Court decision called the bad key decision. It's discussed on page 9 of the compliance guide. In that kind of situation, the two bodies A and B are in practical effect considered to be meeting together. And separate notice, the Open Meetings Law requires that separate notice has to be given for the meetings of both of those bodies. Now, the separate notice can be combined into a single document if certain guidelines are followed. The notice has to identify each of the two bodies. It has to provide adequate notice of the meeting of each of the two bodies, and it should be published or posted in each place where each of those two bodies customarily posts its meeting notices. So don't just put it up in the places where body B usually posts its meetings, and leave the bulletin boards where body A always posts its meetings empty, so that you'd be fooling people, members of the public who are interested in meetings of body A. Now, it doesn't say unless the gathering was social or chance once again. So if the members of body A by chance show up at a meeting of body B, or they're just sitting together and socializing at the meeting of body B, it might not be considered a meeting of both A and B. But how do you tell the difference? Well, look to what did they know before the meeting happened. If the members of body A routinely attend meetings of body B, or if they knew in advance that they were going to be there, then it won't be considered a social or chance gathering. It'll be considered a meeting of both bodies, and you have to follow those notice requirements. And the last thing to note about bad key, though, is that there's one exception. It doesn't apply when all the members of body A that are present at the meeting are also members of body B. So if you have people on the city council who are also members of the planning commission, then the mere fact that they're at the meeting of the planning commission doesn't convert it into a meeting of the city council as well, because the court reasoned in that situation, when the planning commission gave notice to the public of the planning commission meeting, it told the public that all the members were going to be there. So the public already knew that all those people were going to be there, and the additional notice wouldn't really be providing any additional information. So it's not required in that one situation. Now that brings us to the notice requirements, which are discussed at pages 10 to 13 of the compliance guide. And in general, the notice requirement is that every meeting of a governmental body must be preceded by public notice. And the manner of giving notice is covered by section 19.84 sub 1 of the statute. And it requires that notice be given first as required by any other statutes in addition to the open meetings law, and then under the open meetings law itself by communication from the chief presiding officer of the governmental body or that officer's designee to three categories of recipients. First, to the public. Notice to the public can be accomplished in either of two manners. By posting of the notice in one or more public places likely to be seen by members of the public, and we advise, the Department of Justice advises 3 places, if possible, that notice be posted in 3 places, or by paid publication in a news medium in that community that's likely to be seen by members of the public. Paid publication for purposes of giving notice to the public, because you have to be sure that the notice is actually made available to the members of the public. Merely sending the notice to the newspaper without making sure that they actually print it wouldn't be of any use to the public, so that would not satisfy the notice requirement for purpose of giving public notice. Now the second form of notice is notice to any news media that have filed a written request for the notice. So local newspapers, TV, radio stations can file requests in writing asking to be routinely notified of the meetings of a governmental body, and they should receive notice if they've made such a request, and they cannot be charged fees for having that notice provided to them. And finally, statute requires that notice be sent to the official newspaper for the community in question, the newspaper under Chapter 985 of the statutes. That's the newspaper where legal notices for that community are published. Now that notice, the notice to the official newspaper, does not have to be paid publication. If you have provided notice to the public already by posting in 3 places in the community, you also send notice to the official newspaper for the community, it is not necessary to additionally pay to have that newspaper publish that notice, because the public has already been notified and the newspaper has been notified because you've sent them the notice. It's only if you choose to use publication as an alternative to posting that you have to be sure to pay for the publication. Now, the notice, according to the statute, is to be given by communication from the chief presiding officer of the body or a person designated by that officer. So the chief presiding officer is the person who is legally responsible under the Open Meetings Law for making sure that the notice requirements are met. He or she can delegate to someone else the particular tasks required to actually give notice, but cannot avoid liability for a deficient notice by making such a delegation. So if you're the chief presiding officer of the body and you delegate to a staff member the task of publishing the notice, and the staff member makes a mistake and the notice doesn't get published, it is you as the chief presiding officer who will be potentially liable for the notice violation under the Open Meetings Law, rather than the staff person. So you have an affirmative responsibility as chief presiding officer to take special care to closely supervise and make sure that the notice requirements are satisfied. I would refer you to pages 10 and 11 in the compliance guide for more detailed discussion of the methods of giving notice. And then I would like to turn to the contents of the public notice, which is one of the areas that generates the most questions and controversies that we receive. The subject is discussed at pages 11 and 12 in the guide. And what the statute says about the contents of the notice is that the meeting notice must set forth the time, the date, the place, and the subject matter of the meeting. Now, time, date, and place are pretty straightforward. Usually, there's not much ambiguity about how to describe those things. But subject matter can be described. How specific or how general one is in describing the subject matter of a meeting can vary incredibly. At the most extreme, you would say, well, the subject matter is government business or business of the body. Or you could be so detailed that your meeting notice would become incredibly long because every subtopic of every subject is being listed in the meeting. So where in that continuum do you have to be in order to meet the requirements of the Open Meetings Law? Well, the statute provides that notice should be in a form that is reasonably likely to apprise members of the public and news media of the information contained in the notice. And we now have a new Supreme Court decision just issued this summer. It's the Buswell decision, and it's discussed and cited in the compliance guide, in which the Wisconsin Supreme Court declared that henceforth meeting notices will be required to conform to a reasonableness standard for describing subjects. Previously, there was a Court of Appeals decision dating from 1999 that was the only published authority on this subject that had held that a subject description was legally sufficient if it identified the general topic of the items to be discussed. And that case was applied in a very broad way, so that what was at issue in that case was the category on the notice was licenses, and the specific act that the body was dealing with was they had approved a liquor license for a grocery store that was especially controversial in the community, and then at the next meeting they were going to reconsider that previous approval, and they put it under this rubric licenses, and members of the public were expected to be adequately notified that they were taking this rather controversial action in the community under that. Well, and then the court approved the use of licenses in that case, the Court of Appeals, and then that case was applied in turn in a way such that any notice that was at least as specific as licenses, which would be most notices, would be deemed sufficiently specific. So very broad subject matter descriptions were approved under that older case. That was the HD Enterprises case. No more. In that respect, HD Enterprises was overruled by the Supreme Court in Buswell, and it's now being replaced by a reasonableness standard that is case-specific in nature. So in determining whether notice is reasonable, you have to look at the particular facts of the case and ask a series of questions. The court looked at a number of factors, 3 factors. First factor is the burden on the body of providing more detailed notice. How hard would it be to provide more notice in the specific context of the notice you're providing? If it's just a matter of putting a couple more words in your notice, and it wouldn't really be, you already know what those words would be. It isn't going to cost your body any special effort to do it, and it would provide a lot more useful information to the public. Then it's going to be, the courts are going to think it's more reasonable to include that information than to exclude it. The second factor is whether the subject is of particular public interest, based both on the number of people who are interested in it and the intensity of the interest. So if you already know, looking back at the example of the HD Enterprises case, you know this is that everybody in this community is concerned about this new liquor license for this store, or the segment of the community that is concerned about it is really agitated about it. Then again, that's a situation where it may be considered more reasonable to give a little more notice, a little more detailed description of the subject in the meeting notice. Conversely, where it's a relatively routine and mundane subject, a more general subject matter description might be considered perfectly reasonable. The third factor is whether the subject involves non-routine action that the public would be unlikely to anticipate. So if you've got something that is a new subject that it falls technologically, you can group it under some general subject heading that's already on your agenda, but it's really itself a new subtopic that your body has never dealt with before, and that the public would be surprised to learn that you're dealing with for the first time. Again, it's going to be considered more reasonable to describe that subtopic more specifically in the notice, so that members of the public are made aware that you're dealing with this new subject for the first time. So these are sort of principles of reasonableness, and they kind of common sense kicks in when you think about them. Once you've given reasonable notice of a subject for a meeting, then the members of the body during that meeting will be free to discuss any aspect of that subject, as well as issues that are reasonably related to it. So the fact that you've noticed your subject in a particular way doesn't, straitjacket the governmental body into very, very narrowly, not depart. You can have a reasonable discussion of the subject that you have noticed, according to the Supreme Court. Now, in addition to those are the factors that the court discussed in the Buswell case. In addition, the Department of Justice has identified a couple other factors that might be pertinent to the reasonableness of the notice, and that apply in circumstances where the notice itself, standing alone, might look perfectly reasonable. This is situations where the notice provided reasonable notice of what was of the subjects of the meeting, but then that notice is accompanied or followed by other statements or other actions that contradict the notice or that mislead members of the public. One example that I received a telephone call about once was, in essence, a situation where notice for a meeting on Friday was published. The meeting was to take place on Monday. It said that the body was going to discuss subject X at the meeting on Monday. On Saturday, the presiding officer of the body was on the front page of the local newspaper announcing that meeting X was actually not going to be discussed at the meeting of the body on Monday. And then on Monday, the body had its meeting and it went ahead and did discuss subject X. And then when people complained, they said, "Our notice said we were going to talk about subject X." Now, I don't know that, to my knowledge, the situation wasn't litigated, but it's certainly a circumstance where a big red flag goes up. There might be a potential violation in that situation. So we advise governmental bodies to be careful about making statements or actions that are inconsistent with the contents of their notice. If you make such a statement, revise the notice in a way to update it and keep it accurate. Losing my place, just a second. Okay, generic subject matter descriptions. One thing that comes up in notices, and we still see this even though we've, for a long time, told everybody not to do it, is these subject matter descriptions that are things like old business, new business, agenda revisions, other matters, miscellaneous business. These kinds of headings, standing alone, don't describe any subject, and they don't give anybody any information about what subject is going to be discussed under those headings. I understand that things like old business and new business may be customary under rules of parliamentary procedure for structuring your agenda, and that's fine. But the open meetings law requires that in addition to those headings, you include more specific subjects that are going to be discussed under those headings. So just relying on things like old business and new business will be a violation. Same thing goes for member comment periods with designations like mayor comments or alderperson comments. These once again, they don't provide any notion of what the subject is that's going to be commented on. If you're a member of the governmental body and you want to talk about a subject at an upcoming meeting, you should use your body's procedures for getting that subject added to the agenda for that meeting so that the public will have notice that that subject is going to be discussed, and then you can talk about it. But you can't have a member comment period when anybody, member of the body, can say whatever they want. This is distinguished from citizen comment periods, which I'll get to in a couple of moments. Timing of the public notice has to be given at least 24 hours in advance of the meeting, unless for good cause 24 hours notice is impossible or impractical, in which case as little as 2 hours notice may be given. Two things to note. Number one, emphasis on good cause. If you're going to give less than 24 hours notice, you really should have good cause for why it's impossible or impractical to give that much notice. That includes meaning, can this meeting be postponed for 24 hours so that we can provide 24 hours notice, as opposed to saying, well, we'd really rather go ahead and get the meeting over with today, so let's just have the meeting, let's postpone the meeting for 2 hours and give 2 hours notice. If there's nothing that really prevents you from giving the 24 hours notice, that's the preferable course, or you might be found not to have had good cause. The other point is there's no exception to the 2-hour requirement. With good cause, you can get it down from 24 hours notice to 2 hours notice, but there's no such thing as an emergency exception that allows you to talk about something new that comes up during the meeting without giving at least 2 hours notice. I'm going to talk very briefly now, assuming we've determined that the open meetings law applies, we've given notice of our meeting, now we want to conduct the meeting in a way that complies with the accessibility requirements. This is a somewhat easier area of the law, so I'm going to try to move through it very quickly. There are 3 aspects to accessibility: the location of the meeting, the room size and room characteristics, and accessibility for people with disabilities. With regard to location, governmental bodies should hold their meetings in places that are located within the geographical area that the body serves. If you're the Dane County Board, don't go having your meeting in some other county where the people of Dane County will have a hard time attending it. Meetings, it's not prohibited to hold meetings in private premises, but it should not be done unless the private premises are open and accessible to all members of the public during that meeting. And in general, it's preferable to hold public meetings in public places rather than in private premises. The room where a meeting is held has to be reasonably calculated to be large enough to accommodate all the citizens who may wish to attend the meeting. Again, this is another reasonableness standard. If you have reason to believe in advance of a meeting that there's going to be an especially large turnout for that meeting, then I think the governmental body has an obligation to take steps to try to find the biggest room they can find to accommodate those people. Conversely, if it's an unanticipated turnout and they're in their customary room and the room turns out to be too small and some people have to stand outside in the hall and can't observe the entire meeting, that's not necessarily a violation of the law. It may be that the body acted reasonably under the circumstances. If the acoustics of the room are poor or other characteristics of the room make it hard for people to observe what's going on, the members of the body should be taking steps to speak up or to use amplification equipment or to make them move so that they make themselves visible. They should try to make themselves observable by the members of the public. State governmental bodies are statutorily required to have meetings only in facilities that provide functional access for people with disabilities. That state statute does not apply to local government bodies, but we encourage them, of course, to also meet in accessible rooms whenever possible. Finally, citizen participation. This is the part of accessibility of meetings that does generate the most issues for us. In general, the open meetings law gives citizens the right to attend and observe meetings of governmental bodies, but it does not require governmental bodies to allow members of the public to speak or actively participate in meetings. Nothing prohibits governmental bodies from doing that, and it's a great thing for them to do, but the open meetings law itself does not require them to do it. Now, as part of the opportunity, the right to observe the meeting, citizens have the right to record meetings. They have the right to tape record or videotape a meeting as long as it's an open session meeting and as long as the taping is carried out in a way that doesn't disrupt the meeting. And governmental bodies are required to make a reasonable effort to facilitate anyone who wants to record or film or photograph an open session meeting of the body. The open meetings law permits citizen comment periods during meetings, but it doesn't require them. If you're going to have a citizen comment period, you have to set aside a portion of the meeting for citizen comments, and you have to include it as a public comment period in the meeting notice that's published in advance of the meeting. If you've done that, if you've given notice, then during that period, the members of the body can receive information from members of the public on any subject that the member of the public wants to talk about, and they can respond to the member of the public on whatever subject the member of the public may raise. So this is an exception to the rule that you can only talk about subjects that are listed on the notice of the meeting. It's an exception that's intended to facilitate exchanges between governmental bodies and their constituents. But we advise, the Department of Justice advises, that if a member of the public raises a subject that's not on the meeting notice, the discussion of that subject should be fairly limited in nature during that meeting. And if it looks like it's an important subject that's going to require an extensive discussion, we advise that following an initial informational exchange, that the subject should be held over to a future meeting that could be specifically noticed so that all members of the public would know when that discussion is going to take place. In addition, a governmental body, while they can listen to members of the public and they can respond, they can't take formal action on subjects that are brought up during a citizen comment period. You can't actually take a vote on anything that a member of public raises during the citizen comment period, unless that was a subject that was already an item of business on the notice for that meeting. I'm going to turn now to closed sessions before my time runs out. Closed sessions are the other very important subject under the open meetings law. They're discussed at pages 15 to 20 of the compliance guide. The open meeting statutes contain both procedures that are required for a body to go into closed session and specific subjects that can be discussed in a closed session. The procedures are discussed in pages 15 and 16 of the guide. The first thing to note is that every meeting of a governmental body has to begin in open session. There's no such thing as a meeting that begins directly into closed session. If it does, it's a violation of the open meetings law. Before the body can go into a closed session, there has to be a motion to go into closed session made and carried in open session by a majority vote of the body. This is in section 19.85 sub 1 of the statute. And before such a motion is adopted, the chief presiding officer of the body has to announce to everyone present, including not only the members but also the members of the public, an announcement of the nature of the business that's going to be considered in the proposed closed session and the specific statutory exemption that authorizes the closed session. There's a long list of them that I'm going to talk about in a moment. Identifying only the statutory section is not sufficient. So just having an announcement, motion to go into closed session under 1985 sub 1E, that's not an adequate announcement. We also want to include some kind of description of the subject of the business that you're going to be talking about. Motion to go into closed session under 1985 1E to talk about bargaining related to the such and such project. That would be okay. Okay. Once a governmental body goes into closed session, it has to limit its discussion to the specific business for which the closed session was authorized under the motion. And it can't take up any other matters during the closed session. So you go into closed session for a specific purpose that was announced in that motion. You go in there, you do your business on that subject. You don't stray off into any other related subjects that could be discussed in open session, because if they could be, they should be. And then when you're done, you go back into open session, and then you talk about the other aspects, or you talk about the other aspects of the subject before you go into the closed session. But you don't expand your subject after you get into closed session. If you do, it's a violation. One thing we frequently get questions about is who may attend a closed session and who can be excluded from a closed session. The open meetings law generally doesn't limit a governmental body's discretion to decide who it wants to invite into or exclude from a closed session. The body can invite anyone that the body determines to be necessary for conducting the business that has to be conducted during that session. However, Section 1989 of the statutes governs exclusions of members from meetings and provides that a member of a governmental body may not be excluded from any meeting of that body, whether it's open or closed. So you can't exclude a member of the board or a member of the committee from a meeting of that board or committee, whether it's an open session or a closed session. And the same statute also provides that unless the body has a rule to the contrary, a member may not be excluded from a meeting of a subunit of that body, whether open or closed. So if you have the city council and a member of the city council who's not on the finance committee wants to attend a session of the finance committee, open session or closed session, even if it's a closed session, the finance committee can't exclude that member from that session unless the city council has already adopted a rule that allows such an exclusion to take place. So the body does have the ability to authorize such exclusions, but it has to do so in advance by creating its own rule. Now, the statutory provisions authorizing closed sessions are very important. They're located in a list of subsections under 19.85 sub 1, and then they go A through at least J. It might even go further than J, I'm not sure. No, A through J. And each of those describes a subject. If you want to talk about this, for this purpose, a closed session is authorized. Now, I can't possibly talk about all of them in the time available, so I'm going to briefly touch on just a few that are most common and most important and that give rise to difficulties. Sub 1A allows a closed session for the purpose of of deliberating about a case that is the subject of a judicial or quasi-judicial hearing before the body. So if the body has conducted a hearing on some subject and now it wants to deliberate about the evidence, it generally can go into closed session for the purpose of doing that. However, applications for permits and appeals on zoning matters are not considered cases of that nature, and those should be deliberated in open rather than closed session. 1B allows a closed session for considering dismissal, demotion, licensing, or discipline of a public employee or the investigation of charges against a public employee. If there is to be an evidentiary hearing, however, or if formal action is going to be taken in relation to the employee, then the employee is entitled to actual notice of the session and is allowed to demand that it be held in open rather than closed session. So we're going to discuss disciplinary matters of employee X. I have to make sure that employee X receives notice that this is going to take place, and the employee X can demand that it be held in open rather than closed session if there's going to be a hearing or if we're actually planning to take action. If we're just going to discuss something without a hearing and we're not going to take any action, then that special provision does not kick in, and it can be done in closed session, notwithstanding the preferences of the employee. 1C allows a closed session for considering employment, promotion, compensation, or performance evaluation data of a public employee. How does this differ from the previous one? Think of B as being the one related to discipline, and C as being the one related to more general matters related to an employee. Just generally, should we hire him? How much should we pay him? Or how good a job did he do or not do? He or she do or not do this year. C is not the correct one to use. If you're in a disciplinary type situation, you should be relying on 1B rather than 1C to justify a closed session, because under 1B, the employee, under certain circumstances, has those rights to demand an open session. The other thing to notice about C is it applies to public employees and appointed officials over whom the governmental body exercises responsibility. But it doesn't apply to elected officials, and it doesn't apply to members of the body itself. So if you have a vacancy in a staff position of some sort in city government, and the city council is to appoint a new person to fill that position, that staff person is a government employee, and they may be able to go into closed session to discuss that appointment. But if there is a vacancy in an elected office, and the city council is responsible for appointing someone to fill the balance of term in that office, that has to be discussed in open rather than closed session, because that elected official is not considered an employee of the city council. And by the same logic, if there's a vacancy in the council itself and the council members are appointing someone to fill out the balance of a term on the council, it cannot be discussed in closed session. It has to be done in open session. Related to B and C is 1F, which allows a closed session for considering certain kinds of sensitive information described in some detail in the statute about any person: financial, medical information which, if discussed in public, would be likely to have a substantial adverse effect upon the reputation of any person. Now, under this exemption, it differs from the previous two in that the person who is the subject of the confidential information doesn't have to be a public employee. It could be anyone. But the important thing to note is that the mere possibility that sensitive information might come up in some discussion about someone is not enough to justify invoking that section to have a closed session. There has to be some reasonable likelihood. You have to know that something is going to come up. You've got some actual information about someone, and it really would be damaging to them if it was discussed in public. But just, gee, I'm afraid somebody might say something harmful to someone, or that would aggravate someone or hurt someone's feelings. That won't justify the use of that section. And finally, the last one I want to really touch on here is 1E, which allows a closed session for deliberating or negotiating the purchase of public properties, the investing of public funds, or conducting other specified public business whenever competitive or bargaining reasons require a closed session. Now this is the second area where we have a recent court decision. This time it was a Court of Appeals decision in a case called Citizens for Responsible Development versus City of Milton, and it's discussed, I believe, on page 18 or pages 18 and 19 of the compliance guide, where the Court of Appeals applied this exemption and applied it in a pretty narrow and restrictive way. So any time now that you see 1E being used to justify a closed session for competitive or bargaining reasons, a caution light should go on in your head to consult with your attorney, look at the City of Milton decision, and take a look at whether that section is being properly applied. The court held in that case that the burden is on the governmental body to show that competitive or bargaining interests require confidentiality, and that the use of the word require limits the use of that exemption to situations in which the competitive or bargaining reasons leave the governmental body with no option other than to close the meeting. So it can't just be, well, it's more convenient, or it has to be it was narrowly construed, no option, no alternative to closing the meeting in order to protect the body's interests. I think it's a fairly fact-specific case, so I would encourage you, if you have an issue, to look at the case. There were a whole string of reasons that the city in that case gave that were rejected by the court, and they're specific enough that it's very hard to tease out of them a general rule that I can tell you for the kinds of reasons that a court won't accept. But if you look at it, you'll see some examples of things that the court did not accept, reasons that before this case, an attorney in this area might have thought that they would have been acceptable reasons for closing a session for bargaining or competitive reasons, and the court rejected them. What the court did accept was that the portions of meetings that had been closed for the specific purpose of developing negotiating strategy or talking about prices related to the public project that was at issue in that case, those portions of those meetings were appropriate for closure under the competitive or bargaining exemption. But a lot of other reasons having to do with a private developer had requested confidentiality, or there were concerns that public statements might attract in other private parties who would compete in relation to this public works project. Those reasons were rejected by the court. So it's an area where caution and further study is going to be needed. I think I've probably gone over my time, or I'm out of time at any rate. So I'm going to stop. I'm going to stop at that point with the concluding remark that there's a lot more to the open meetings law. I didn't get a chance to talk about the enforcement provisions. There are numerous other closed session exemptions that I didn't get to talk about. So again, I encourage you to look at the statute, look at the guide, and look at the other sources. Call the Attorney General's office if you need further help. And thank you very much for your attention.